You may have seen in the news or heard on the grapevine that there's been introduced a private parking code of practice, which should give you some kind of grace period so you won't get a parking charge notice, the private kind of fine, if you overstay your parking. But as usual, it's not that simple. If that's what you've heard, then don't get too excited about it because I'm here to shoot that down. Don't shoot me, the messenger, down, but it's not quite as simple as that sounds, and it's not even as positive as it sounds. Now, before we go on, if you're new to me, I'm a barrister of England and Wales. I'd love for you to subscribe to my channel. I give you frank and objective guidance on this channel on the law. But let's go back. First of all, there was a private parking code of practice, which was to be underpinned by legislation, was introduced and then quickly withdrawn. So it was published in February 2022. The private parking community raised objections and it was withdrawn. They ran back under the rock in June 2022 and this guidance was withdrawn. There was a lot of good things about this, which would have cleared a lot of things up, but alas, that was withdrawn. It has now been the case that this private parking sector single code of practice, version 1, has been brought about. But make no mistake, this is a self-authored code and it is not backed by legislation. What that means is the people that wrote this and the people that subscribe to the organization that wrote this agree that they must comply with it. But there's no results in law if they don't do so. This is just a self-authored code. But also important is the scope for this, because if we go down to the scope here, this only applies to members of the British Parking Association and the International Parking Community. Those are the accredited DVLA trade associations. And just to explain that briefly, if you park in a private car park and you overstay and they want to issue you a parking charge notice, they will need to get the details of the registered keeper of the vehicle, because at least in England and Wales, the registered keeper of the vehicle is liable for any parking charge notices. It's different in Scotland, but keep watching because this might be interesting to you anyway. So they'll need to be a member of one of these organizations to get your details from the DVLA. DVLA is unlikely and really shouldn't provide those details to anyone that is not a member of a trade association. However, this code only applies to members of the British Parking Association and the IPC. So anyone else, it doesn't apply to. Now, why is that important? Well, because I did a video not too long ago where one company was a member of the British Parking Association and obviously had to comply with their general guidance and rules and code of conduct and so on. But then at the time that one of you guys sent me an email disgruntled about what had happened because you'd received a parking charge notice from one of these car parks, I looked into it, and it turns out that using the Wayback Machine archive.org, do go and support it and give them a donation. This is not a sponsored video, but it is a fantastic website that gives you a snapshot of what these websites used to look like. It's excellent for research purposes when you want to look back at things like this, at the previous list of the British Parking Association members on their website, what it used to look like. And so in short, the company that was complained of used to be a member of the BPA and was not at the time that they issued my viewer a parking charge notice. Now that's important because it meant that they just at some point thought, well, to hell with all the rules and the guidance and the code of practice in the BPA, we're going to do whatever we like as a private company, which they're entitled to do. But it also means that they shouldn't be able to get the details from the DVLA, although I wouldn't be surprised if they somehow managed to get the details from the DVLA, because the DVLA might just assume that they once were a member, so they're on a list or something. I don't know. I would hope that they keep their records up to date, and I would expect that they do so, but things happen. One way or another, they issued this parking charge notice to my viewer, was disgruntled about it, and then lo and behold, when I investigate it, they are no longer a member. Now, coming back to why that's important is they, along with many others who are not members of the BPA or the IPC, will not have to comply with this self-authored code. That's under the scope. Scope just means who does this apply to, what areas does it apply to, and how is it going to be used. And so, in essence, it's going to be used in that way. Now, it does say here, parking operators who comply with the code will be entitled to request registered keeper detail from the DVLA, etc., etc. This code does not apply where civil enforcement regulations or their equivalent apply on any public roads or regulated car parks. In other words, the penalty charge notice civil enforcement kind, it's nothing to do with that, nor does it apply to non-members of the BPA or the IPC. So as I said, nothing in this overrules any bylaws, any legislation, any other actual law. This is just a code by which the members of these organizations apply. Now, the reason people were excited about it was because it talked of a grace period. Because I've had people tell me that even within a few seconds or within a few minutes of their ticket expiring, they've come back, they've been delayed for one reason or another, and they felt it entirely unfair that they've been given a parking charge notice because they were 30 seconds over. Now, I would argue that in court any day of the week to say there's no way they can be absolutely certain that their clock versus our clock was absolutely spot on to the period of 30 seconds or whatever it was. Therefore, on the balance of probabilities, there's no breach of contract here. And in any event, if they were penalizing them because of a minute or two either way, technically they might be in breach of contract. But is that fair? Now, if terms are ambiguous or any other way unfair to a consumer, then they're not enforceable. So whilst that could go either way, a court could say, well, technically you're in breach of the terms and conditions, therefore pay the charge. Or you might get a sympathetic judge and say, now, come on, this was 1 or 2 minutes. Be realistic. Now, the point of a parking charge notice in the first place is to compensate the landowner for the loss of any profit that they would have had from someone genuinely using that car park, paying the fees that they were supposed to pay for the parking period they're supposed to pay for. Now, if it's 1 minute over, are they really going to justify 50, 70, £100 parking charge notice for the 1 minute that you overstayed? That doesn't really dispossess the landowner of that small space of land whilst you're on the way back. But that's an argument for court, and it could go either way, so just bear that in mind. But alas, this grace period will only apply as it's set out in this code, which is even worse than it might sound at the beginning. You might think, great, there's a 10-minute grace period for all the car parks that are members of the BPA or the IPC. Not the case, because if we jump down to, actually, if I show you here, it says the grace period is set out in Annex B to the code to allow by the parking operator in addition to the parking period, and the charge must not be issued during in that grace period. But if we go down to this table here, table B1, it says the grace period for land that's open to the public. If it's free for a period of 1 hour or more, you get a grace period of 10 minutes. If it's free for a period of 1 hour or more and it's got more than 500 spaces, you get a grace period of 10 minutes. If there's a tariff for parking, you pay up front for a specified period, pay and display, you get a grace period of 10 minutes. If there's a tariff for parking, you pay on departure. So you pay at the barrier, you get a grace period of 10 minutes. But there is a footnote for that. Needs to recognize how long it would reasonably take to travel from the payment machine to the vehicle thereafter and exit. But areas that are restricted, such as tied to an event, a custom or a short stay, pre-booked permit areas, and those sort of things, all but the permit areas, there is no grace period. So that doesn't even apply to everywhere, but it does apply to the open to the public, free for a period of an hour or more, free for a period of 1 hour or more with more than 500 spaces, standard pay and display, pay on exit, book in advance. Each of those get a 10-minute grace period subject to the footnotes here. You'll also be pleased to hear that the general terminology has been restricted, so they must no longer, which I've always objected to, must no longer use the words inappropriately. Now, that is probably an objective assessment on a self-authored code. In my view, doesn't really mean very much, but they will self-author the code. They shouldn't inappropriately use the following terms: offence, offender, offending vehicle, order of recovery, notice of intended prosecution, illegal parking, crime violation, fixed charge, fine, penalty, bailiff, penalty charge, notice. Now, I've particularly picked up on the word bailiff before now in relation to debts. More about that in other videos. Because all of these words suggest that it is all about something legal. Now, whilst it is technically a legal thing, a breach of contract, all of these things suggest that you're doing something criminally wrong or a civil violation for which you could get a fixed penalty or penalty charge notice or something like that. Obviously, you can't on a private car park, so don't worry too much about those, but they should stop using all of these words. But again, only if they are a member of the BPA or the IPC. They must also not use terms that would mislead the average customer or make them reach a decision that they might not otherwise have made, including the word summons, justice, prosecution, excessive use of the word county court judgment, because you get these parking charge notices to say, you might get a county court judgment against you if you don't sort this out. which is, of course, true, but that's true of any breach of contract. If I have a client that doesn't pay me my fees and I threaten to sue them, which I'm allowed to do, then I could say that this, be warned, this could result in a county court judgment against you. But you can't use that excessively to put pressure on somebody. You can just warn them. It's fair to warn them, but not excessively. And again, earnings attachment or attachment of earnings, as it's properly called, or bankruptcy. They shouldn't be using any of these terms. And I agree. They shouldn't be using these terms because they are threatening, they are heavy-handed. Whilst they're all technically true, it's not something that they really should be using. So all in all, better than nothing, but has been criticised already. Mr. Cousins, who I believe is head of roads policy at the AA, said that this code of practice was simply a watered-down version and falls far short of the standards of the AA, government and consumer groups have called for across many years. He said, and I'm quoting from the BBC here, he said, this self-authored code doesn't acknowledge the need to cap charges and remove debt recovery fees. These elements are desperately needed from the government-backed code to protect innocent drivers from the sharks running private car parks. Simon Williams, head of policy for the RAC, also said drivers shouldn't be fooled into thinking that this so-called code, developed by the private parking industry itself, is the same as the long-delayed official private parking code of practice that is backed by legislation. This, and only this, will bring an end to the worst practices of some private parking operators and mean drivers, especially those who are vulnerable and are protected from unreasonable fines and debt collectors chasing down payments. In other words, they are of the view, and I would agree, that this private parking code of practice seems to jump the gun of the government official parking code of practice, which would have been and should have been underpinned by legislation. And therefore, I get the sense, now this is my opinion alert here, I get the sense that this has been published to try to deter the government from pursuing their own legislation-backed code of practice for parking operators. Because I get probably, along with TV licensing, more complaints about this than anything else. Because people have received these parking charge notices that they think are unfair, in many cases unlawful, and in many cases just immoral and unjust, and I would personally fight them out of principle. So I will continue doing that fight for you here, especially if you subscribe and we hit 500,000 subscribers. I would love 1 million subscribers. About 2 million of you a month watch my channel. 2 million unique viewers watch it, to 3 to 5 million views a month. I would love to hit that 1 million mark. It's been a goal of mine since I started in the lockdown. I just thought to myself, if I could help 1 million people understand law, I would know that if I've got 1 million subscribers, because you only subscribe if you find this useful. So please do that if you found this useful, of course. If you didn't, I understand, but hopefully you do. And I like to be objective. I like to be helpful. So please do subscribe. Thank you for watching, and I'll see you next time.